Hello, everybody. It's 12:59, and we're just about to get going here. Dave, you there?
I am.
Okay, let's fire this up. Thanks, everybody, for joining, and I know some other folks will be jumping in. This is Paul Hitchcock with Barth Calderon and Wealth Protector TV. Really excited to have my colleague Dave Singh on. Dave, are you going video or no video?
No, I'm glad to go video. I believe it's disabled.
Oh, it is. Okay, let me make sure I got you here. Hang on. Okay, try your video now. You should be fine.
Okay.
Right, there you go.
There we go.
So yeah, really happy to have my colleague Dave Singh here, who's an expert attorney in estate planning, probate. Welcome, Dave.
Thank you. Thanks for having me.
Yeah, and a lot going on, obviously, in the world of estate planning and probate. And so, Dave, jumping into this, maybe you give us a little kind of background on the current landscape that's going on, and let's jump into how to avoid probate, estate planning best practices.
Absolutely. So we can kind of think about that in two different ways. So one is what's going on right now, and this is a really active time in the estate planning world, which, that's not always the case, but this year in particular, there are things going on that make estate planning very, very relevant for lots of families. Even though they may not have thought about it before, there's a lot that could impact them. But the thing that's always been there is that in California, if a family is not, if they haven't planned correctly or properly, I guess the way that we would recommend, that most estate planning attorneys, maybe all, would recommend, if that hasn't occurred, then there's a risk of probate. And in California, what that is, it's a court supervised process when someone passes away. So it's treated as, this kind of big boogeyman, in the closet situation. It's actually not the end of the world. It's not the worst situation. It's just it does take a long time. This is probate I'm talking about. It does take a long time, and it is expensive. Attorneys like myself, other probate firms, we are compensated on a percentage of the estate basis, and that's set out by statute. And so it can be expensive. So an estate in California, it's very easy to find a $500,000 estate, which consists of a home,
Right, yeah, a garage.
any home here in Southern California. And what's interesting is that the court doesn't take into account, or the statute actually doesn't take into account, liabilities. So you can have a $500,000 home, $499,000 mortgage, and the attorney's fees on that are going to be calculated on the $500,000. And in California, that's a $13,000 attorney fee for going through probate, for the probate process. Whoever's appointed by the court to be in the driver's seat, so the actual client that we would work with, the representative of the estate, they're entitled to the same fee. And so although they don't always take that fee, they are entitled to it. So just to administer a $500,000 estate, which is actually on the low side here in Southern California, just to administer that estate could be $13,000 or could be $26,000 if both the attorney and the representative take their fee. On top of that, there's typically $2,000 to $3,000, sometimes slightly more, in other costs. So these are court filing fees, publication, could be a bond that's required, several other things that come into play. So now that $500,000 estate, potentially could be $29,000, maybe close to $30,000, just in administration costs. All of that, every dollar of that is not going to your family per se.
Right, yeah. So if you got an estate with a house, stocks, bonds, and cash, do they count retirement accounts in that figure? You got 401ks, IRAs?
Yeah, it depends. What we run into sometimes is, and this is why it's really important for the planning process, which we'll spend some time on, is making sure that the plan is actually funded and that things like beneficiary designations are up to date. What we've seen, for some reason, we have two or three cases like this just recently, where we have a retirement account or a life insurance policy, and there's nobody named as a beneficiary, and so that creates a probate asset, and that means that asset itself has to go through the probate process, so it becomes part of the estate of the person who passed away. So that's as a side consideration, I think that's another thing to look at as we're thinking about planning, is we always want to make sure that those beneficiary designations are in place as well. But going back to the probate process, I think something interesting that you brought up is, so yes, it could be a $500,000 home, it could be $500,000 in the bank, it could be a retirement account, and I'm using 500. We have estates that are much smaller, of course, but what if the only asset in the estate is a piece of real estate, and what if the family wants to keep that property in the family? So now we have a situation where we have an asset that is illiquid. So there are no funds available to pay attorneys, to pay court costs, to pay the executor if they choose to take the fee, pay the bond, do all these things that have to happen during the course of a probate. But you do have this property. So there's only a couple of different ways that this goes. And, either if the property has to be sold to create some liquidity, that's one option. That's a fairly straightforward option. The other option is, you have the people who are inheriting the property, they pony up their own funds to cover these types of costs to ultimately inherit.
If they got it, if they're liquid themselves, right? Yeah,
exactly. And very, I would say more often than not, in these situations, in probate situations, the heirs are not in a position to do that. Not typically. So then we have to get creative we look at financing, or what can we do during the course of the probate to create some liquidity in the estate. And so that is, that's a challenge that every case that we look at, we have to position it properly so that it can ultimately create some liquidity to take care of legal fees and court costs and things like that. So that's a challenge as well.
What about the emotional factor, Dave? I mean, when you get to probate, because things aren't laid out and there isn't sort of this living trust that is the document that says, okay, here's what's going to happen.
Mm-hmm.
I know the answer. It's a rhetorical question, but families get broken up all the time, and there's family fights, and relationships are destroyed
Mm-hmm.
through the probate process, right? Because there's no clear path. And is that a fair statement?
I would expand on it a little bit, and I wouldn't want to overstate it. So we do have a fair amount of conflict in probate environments. And we also, what I see is a fair amount of conflict in trust administration environments. So the family conflict is not necessarily, I don't really tie those two together. Family conflict is kind of its own category of thing, and it can occur in either environment. But if you're in a probate environment and a conflict arises, now we're dealing with court every time, and now that can easily spin into litigation. We're already in court, so now when there's conflicts, those conflicts are now objections that are filed in court, or
I got it.
there are petitions to remove someone as the administrator, various things, petitions to compel accountings. There are different things. Everything is formal in the probate world. So those conflicts, tend to feel, I think, a lot more severe than they are in the trust administration world, where we are operating privately. There are certainly times that trust administrations, even though they're outside of court, initially, they do end up in court because of various things that happen during the course of the administration. But typically we can keep things out of court. We can negotiate with the parties. We can, mediate in the sense of we're not acting as a mediator, but we are acting on behalf of the trust. We are representing the trustee of the trust and sometimes it's the problem isn't with the trustee itself. It's between beneficiaries. And so we have those issues, but I wouldn't say that either a trust or probate is immune or more susceptible to conflict.
Got it. No, that's a great distinction that you made. And recently you and I were talking about conflict in a trust administration that you're working on. Um, yeah, and which I know you well enough to know that as you approach these situations, you have to go into it also with a mind of understanding the landscape of the relationships between the people, because you're really focused on conflict avoidance, right? I mean, you just don't want to even go down that path.
Right, right. And so, I think in terms of at the beginning of the case, the way that I think about a case is, what are the moving parts here? And each case is unique in that sense, but typically we have certain categories. So a probate case, we may have right at the beginning, who is going to act on behalf of the estate. So we may have three siblings. We've been approached by one of the siblings. This is an actual case I'm talking about. And so we represent one sibling. On the other side are two other siblings, and they seem to have kind of teamed up. And one of them wants to be the person in the driver's seat of the estate, wants to be appointed. And so under the probate code, siblings are actually equal. They have equal preference. There's
Oh,
not, it's not like the eldest sibling has higher, preference or anything like that. They're in equal, they're on equal footing. So when the court is looking at it, they're really looking to the attorneys to say, can you guys work this out? Can you figure this out? Or do we need to go down this road? And a year from now, we'll actually start the probate administration because we'll finally have somebody in the driver's seat. You know, that's where we look at, are there conflicts that right at the beginning we're going to have to address, and that will change the way that we approach a case. On the trust administration side, we can get a sense pretty early if we're starting to see that things will be conflicted, or if we have a bad set of documents to begin with, because we don't have the luxury of only administering our trusts, right? Very often, I would say, more of our trust administrations than not are of trusts that were prepared by other firms or other attorneys, and so maybe decades ago, right? And so when we get them, the form that we find that trust in, at that time is not always pristine. So
what makes them a bad? What makes it a bad trust where you got to fix things?
yeah, so that's the thing. One, can we fix anything? Maybe we might not be able to fix anything at that stage. But number two, do we even have a complete document, right? And that's sometimes the hardest part is, we'll receive a trust and it's missing entire sections of the trust document. It's a binder and sections are missing, or this is a recent case that we had. There's a trust with is something like 20 pieces of real estate in the trust, and that's all great. Everything was fine, except on the front page of the trust, there was a big X drawn through it in ink, in blue ink, big X. And so what do we do with that?
Does that make it invalid when you have an X?
Yeah, potentially.
Huh.
So it would seem like it, but we need to verify who made the X. We
Yeah.
just arrives to us, right? And
Yeah.
so, that case had a lot of other things going on as well. It had some handwritten, separate instructions, which, the question was, is that a will now, or is that an amendment to the trust? So the importance of planning ahead is making sure that it's certainly establishing what the intent of the person creating the trust, or the people creating the trust, is, but it's also making sure that everything's up to date and really clear and cohesive, and not in bad shape, because the people that are going to have to interpret this document are not going to be the people creating the document. And that may be true for the attorneys as well. It's not always going to be that drafting attorney that's going to have the ability to interpret and go back and look at the file notes and say, well, it was our client's intention with this language to, they meant to say this, or this is what their intention was behind this language. We don't always have that luxury of that background information. It's really coming to us as a fresh document, and often it's in bad shape. So.
Very interesting. So what on the front end, what are the best practices of the estate plan? Like when if you're starting out, what do you counsel people to do, and hot button issues they got to be focused on?
So we do a fair amount of trust reviews, and we don't, legally, it's essentially a hot potato. So the last attorney to touch a document, it can be held responsible for that document, and potentially for the work that came before that, because there's dependencies there, right? If you make an amendment and you're modifying provisions in a previous document, now these things are all kind of tied together. So we're very careful about that, and looking for, whether that is the right course of action, or whether we want to think about a complete amendment, which is going to override the entire all, the previous documents. It's going to override those, supersede, and essentially that document becomes the working document, that becomes the trust. So best practice is certainly to have documents reviewed. I would say at least 3 to 5 years is what I advise our clients to do. But upon the occurrence of any life event, so that could be new child, new grandchild, could be new properties, could be spouse passed away, child passed away, those types of things. Let's take a look at the documents, and there may not be anything to do in that moment, but it's important to know whether there's something to do or not. That way, should those documents become necessary, or when that time comes where they have to be administered, at least we're on solid footing during that administration. We're starting off on the right foot, at least.
Is there nuance to like the healthcare directives and the financial powers of attorney? I mean, when you get into those documents, isn't there some level of nuance there where they can apply to different situations in somebody's life? So you got to make sure those are done, right?
Well, yeah, exactly. And this is why, I mean, we definitely want to have these documents in place as early in a client's life as possible, as feasible, because if we can't predict when illnesses will occur, we can't predict the severity of an illness. And so sometimes, and it's sad when it happens, sometimes what we'll see is that, there's all of a sudden, or it could be an accident, right? So it could be something just very instant, and a client is in a medical situation, and they may have a healthcare directive, but it might have been prepared 10, 15 years ago, and the person that's listed is no longer around, or the person that's excuse me, the person that's listed is no longer in the state, or they're sick themselves, right? So all of these types of things happen. So that's why revisiting these documents is very important. And typically that's not going to be a huge expense for clients to look
Right.
at documents. That's not really what firms are in business to do, is to look at documents. And we're not in the business of creating artificial work as well, just responsibly, ethically. It's not the way that we do business. The work that we do is, hey, you have somebody listed here who is no longer around. Okay, that's an obvious one. Or you have somebody listed here who you've mentioned you don't have the best relationship with any longer. Should something happen to you in this moment, that person would be authorized to make medical decisions for you. Are you comfortable with that? Right.
Right.
So those are situations that, absolutely we want to correct, and we want to do it well when we have the opportunity to correct, meaning the client still has capacity. They still have, the ability to think for themselves, make those decisions for themselves, and they're very clear about who they want at that time. So all of that comes into play. I think the general theme is it's important to get the planning in place to create that foundation, but we also want to inspect the foundation and make sure there's no cracks arising in it either.
Right. And when you got a husband and wife, and they are the trustees of their own trust, and then if one spouse passes away, is it always the case where then they've got to have a successor trustee there? There's one parent alive. How does it work with the kids?
Yeah, so that's the situation, right? You know, typically we have one spouse that passes away first. Of course, like we have situations of what's called simultaneous death. You know, a couple is traveling, or but that's very rare. I can't think of one case that I've had with that actually.
Yeah.
You know,
Yeah.
so the more common situation is one passes, and then you know maybe the second spouse, the surviving spouse, passes shortly after that. We do actually see that quite a bit, but we still have that window and we have that opportunity. So the most common framework that you'll see here is that the surviving spouse will have full control over the trust. So they will
Right.
remain in the driver's seat. They're going to have the ability to. So sometimes they may even have the ability to make changes. That's something that we'll counsel clients, you know, on. Do you want the surviving spouse to be able to modify the trust to adapt to future circumstances when you're not around? That's a wait and see approach. You know, children are getting married. We don't know if their marriage is going, how the marriages are going to go, but
Right.
you know, maybe there's some adjustment that's needed in the future. We want to give the surviving spouse the ability to adapt the plan to the circumstances at that time, years and years down the line. So, so I would say that most commonly we would have the surviving spouse as the sole successor trustee. So they would be in the driver's seat themselves, just by themselves. And then they may or may not have the ability to make adjustments to the plan. That's kind of a separate planning consideration.
But what about when they get older? And let's say they start
Yeah.
having a long-term illness, cognitive stuff going on. I mean, when do you have somebody step in there, you know, where they're not the sole trustee?
Right, right. So that's where we would look at in the trust document itself. There are you know, a few provisions that you would want to look for, that a client would want to look for. We want to look for provisions relating to how capacity is defined, right? What makes someone incapacitated under the document, and what are the requirements for establishing incapacity? And so, in a situation like that, if the person, if the spouse, surviving spouse, is, you know, has capacity, they could voluntarily resign. And as we know, capacity is not a, it's not a light switch, right? It's not like
Right.
one day you don't have it. It's a
Yeah.
spectrum, right? And so if they recognize that they are starting to decline, they may voluntarily resign, and then the children can step in. If it's more of a, you know, let's see what the doctors have to say, then usually there's a procedure for one doctor to you know, make an assessment, and then the next trustee can step in, as long as there's cooperation among the parties. But if it's more of a contested situation, and the parent is saying, well, I still know what's going on, I still want to act, then we might look at a two doctor situation, or court involvement
Mm-hmm.
to make that decision. So
Mm-hmm.
things can get, you know, they can get a bit hairy, you know, in that scenario. But thankfully they tend to be fairly, it tends to be fairly clear that someone is losing capacity, and the doctors hopefully are on board. But we do have to watch out for the relationship with the children. So
Right.
yeah,
Right.
that,
Yeah. Which I was just thinking about that. Uh, do you counsel clients on, you know, when the parents are of sound mind and they have a trust? I've often heard, you know, it's ideal to have a family discussion, you know, assuming the family kind of gets along, instead of parents get sick and now the kids are finding out for the first time what's in the trust,
mhm.
you know, that, you know, how do you feel about that? Having family discussions, do you advise that?
I think it's a great idea. So to the extent that the family dynamics support that,
Yeah.
that's something that I try to do. We encourage is being able to sit with the children as well. You know, have a roundtable. Um, Clients have to consent, of course, right? This is their legal work. There's attorney-client privilege going on here, so we have to make sure that everything's on the up and up from that perspective. But beyond that, once we've cleared those hurdles, right? Um, now we can have a really open discussion with the children about this is what the future looks like based on the documents that have been prepared. This is what's in place. Depending on the client, they may or may not want to get into the actual distribution, but they may want their children to know, look, this is the person or people who I'm putting in charge of carrying out my wishes. I know what I'm doing in this moment. I don't want anyone questioning me. And it's amazing how powerful that is. Even though, legally it doesn't make the document more effective or less effective, but it's amazing how powerful it is for children to hear that out of their parents, in their parents' own words in person. That can diffuse a lot of future conflict, just that memory of that discussion.
Right. Also heard you and others at the firm talk about giving assets to kids where parents can actually in their own trust document set it up so that upon their passing, a trust is created for the benefit of the children. So instead of the children just getting stuff, which could be exposed to a lot of things, liability and ex-spouse, where it can go into a trust.
Right.
What do you think about that?
No, absolutely. I think that's the advice, or that's where I start, right? That's what I would like to see for 100% of my clients. But does it always make sense? I mean, sometimes we have clients that their children are in their 60s,
Right.
or potentially even older. And so the amount of protection that they need or want for their children at that stage may not be the same as a younger family that is leaving, and it doesn't have to be substantial. If it's substantial to the family, that's what matters.
Right.
And so they're leaving their assets to their child, and maybe their child, at that time is 5 years old. They've got a lot of life ahead of them. And what does inheriting, could be a life insurance policy plus liquid assets plus a piece of real estate plus some vehicles. Mom and dad go on a trip, and the worst case scenario happens. What would that do to the child to inherit all of that stuff at the age of 16,
Right.
17,
Yeah.
18, 19, 20, the way that we think about these things it's not that, yes, it's great, they'll be provided for, but what is the other side of the coin, right?
Mm-hmm.
What could this do to their life in total, right? Is it going to throw them off their path? Is it going to disincentivize them from pursuing education or any of their other professional aspirations? And what is the impact of this if it's received all at once? Not to mention they're gonna potentially have a lot of new friends. There are things that we we see. I think some of it is fairly obvious from we see it around us. And so those are the things that we want to protect against. And then of course there are outside creditors, lawsuits, divorces fall into that category as well. So how do we protect against those things? We would look at dynasty trust planning is what you're referring to there, and that can be very effective.
Yeah, Dave, it's great information and very thoughtful approach to estate planning. I think a lot for all of us to grab onto here. And I wanted to say too that I put in the chat there for everybody a way to get one-on-one with Dave. So for anybody that shows up and shows interest in our education, we put out a ton of it. We have a complimentary one-on-one planning assessment. No issue is too big or too small. And maybe you're helping your elderly parents, maybe it's you, maybe you're an advisor helping other people. Happy to get you one-on-one with Dave on a call or a Zoom and get you some direct input on how you need to be organized and updated. And there's a lot coming down out of Washington right now. We didn't get into it. That's a big discussion on new laws, on estate taxes. I mean, it's incredible what's going on there. So there's a lot to keep on top of right now. So take a look at that. You can email me there if you're interested in that. Dave, as always, it's great to have you on. Appreciate it very much. And I know we'll have you on again and keep talking about this stuff.
Thanks a lot for having me.
Okay. Thanks, everybody. We'll see you next time.